SJC-11726, Roberta Rodman, George Rodman.
Good morning, Your Honors.
Wait, just hold on a minute.
Good morning, Your Honors. My name is David Cherney from Atwood & Cherney in Boston on behalf of the appellant George Rodman. This case regarding the application of the retirement provisions of the Alimony Reform Act comes to you in a little bit of a different setting than the Chin versus Marriott case that you just heard or the Doctor case that you're about to hear after me. This comes to the court on a reservation and report by Judge Roach as to whether or not these provisions regarding termination upon retirement are applicable to pre-March 1, 2012 judgments. I think that I've listened to what counsel has said. I've read the briefs in this case. I've read the amicus briefs that were filed in this case. And what becomes clear to me is that while the new act does provide sweeping change to the landscape of alimony in Massachusetts, on the one hand. On the other hand, all it does is clarify and provide guidance for issues that were already, prior to the enactment of the Act, available to alimony payors or alimony recipients. For example, while there are certain presumptions that alimony shall terminate upon reaching retirement age, alimony shall terminate, be modified or suspended upon cohabitation, etc. All of these provisions are not absolutes. All they do is provide guidance and provide a burden shifting.
In the Act or pre-Act?
In the Act itself. The Act talks...
More than presumptions, aren't they?
I'm sorry, Your Honor? No, in the Act regarding cohabitation, for example, it says that maintaining a common household shall terminate, suspend, or
right.
reduce.
So I'm just saying it's more than a presumption.
Well, but then what the Act does go on to provide for a burden shifting, for the court to be able to deviate from those presumptions, for the court, whether it be in a modification action or an initial divorce judgment, the court has the authority and broad discretion within the Act itself to deviate. So it's not as if somebody comes in and says, or the Act doesn't say, if you hit retirement age, and you're age 66, for example, that alimony is over and it can never be awarded again, that's it. What it does do, in this particular case, to Mrs. Rodman, is shift the burden to her to come in and demonstrate to the court why it should continue. And what it changes is it says that she has to show a material change in circumstances since the entry and prove it by clear and convincing evidence. Clearly,
if this were a post-March 1, 2012 judgment.
Well, but if this were only restricted to judgments entered after March 1, 2012, why would there be discussion over modification of judgments? Why is there any discussion in here about the court on an initial or a modifying an existing judgment? There wouldn't be any provisions in here regarding modification at all for pre...
Well, it says, but the language of Section 4 that I think you're talking about, the same three conditions, it's what precedes it is alimony judgments entered before March 1, 2012 shall terminate only under such judgments or a subsequent modification. That doesn't say anything about how the modification is to be governed. It just says it'll terminate if you have a modification of a pre-12 judgment. That's probably going to tell you something about when it terminates.
I think that's the point. If the suggestion is...
But it doesn't suggest that the new law is going to govern that modification. That's all I'm saying.
I suggest it does exactly that, and it does make those provisions, and that's part... I think that part of the phase-in of the ability to come in and seek a modification is, as Justice Duffley pointed out, the flooding or the not to flood the courts with these actions, but also I think it does set the standards here going forward in giving all of alimony payors and recipients in Massachusetts. Keep in mind that as prior counsel indicated when they were discussing the Pierce case, and I had the pleasure of standing before this court back in 2009 arguing the Pierce case on behalf of Mrs. Pierce, and the ramifications that came out of that case and the impetus I think that it did to kickstart in the reform of the Alimony Act in this case that hadn't been really revamped in almost 40 years, that the need for predictability, the need for people to know that alimony would terminate, the need to impose limits on the length of alimony, whether it be through cohabitation, durational requirements, age requirements, the definition or the establishing the confines of transitional alimony, rehabilitative alimony, and all of that really speaks to the issue of what the legislature wants people to know as to the parameters for alimony going forward, not just for alimony for post-March 1st, 2012 agreements.
If that were the case, what do you do about the first clause of the first sentence, or maybe the only sentence in Section B of 4?
I think Section B talks to the issue about the provisions of 48 to 55 not being deemed a material change of circumstances in and of themselves, deals with the issue that you still need to come to the court and prove the elements of what the material change is. For example, it may be a simple matter, but the person filing the complaint for modification, or the person seeking to terminate alimony at age 66, can't just stop paying. They need to come to court. They need to file a complaint for modification. They need to prove the bases for it, i.e. that I've reached retirement age. And then the burden shifts if there's a request to continue. Somebody seeking to terminate, suspend, or reduce based on cohabitation has to come to court, prove the event that's happening, and then once they've done that, then the burden shifts to the recipient to demonstrate whether or not there should be a deviation from those limitations by the trial judge based upon the facts. In my case, it was not a bench trial or it was not a trial. In my case, there was a motion to terminate support filed before Judge Roach. And it was at that point, even though there were financial statements filed, there was no presentation of evidence. We never even got to the point where Mrs. Rodman had to meet that burden or even try to meet that burden in this particular case. But I think that the issue here is that when we talk about applying things prospectively, that really is the right to recoup, as I think Justice Botsford, you indicated. For example, I can tell you...
That's not my position, that all it means is recoup.
No, I'm suggesting that I think that that's the definition. I think that's the intent. I've tried a case where the payor was age 76, and we filed for modification in the probate court over in Middlesex. At that point in time, I couldn't come in and say, well, he's been paying for 10 years. He was entitled to stop paying at age 66. Therefore, in addition to stopping it today going forward, I want the recipient to repay the last 10 years of alimony that have been paid. I think that's the prospective nature that the Act talks to, because I don't think that would be fair that somebody who has lived their life based upon a receipt of certain monies would then have to disgorge it or give it back.
What about the fairness of a negotiated agreement that has, as in your client's case, an alimony payment being made until death or of either party or remarriage of the wife? Why is it fair to walk into court and say, well, I'm now, even though this is general term alimony and we've been married 39 years, I'm now able to say, goodbye, Mrs. Rodman, I don't owe you a cent. Why is that fair?
I think that that's where I'm suggesting that the alimony statute is not that changing, because people with a merging agreement or people who had a judgment always had that right to come in and do that. They could come in and say, my ex-spouse is cohabiting. On a material
change in circumstances being shown, right?
That's correct. So what I think...
But you're suggesting you don't have to show that.
Oh, I think that in these certain circumstances where the legislature has defined or clarified those certain parameters, then I think that that's what the legislature does in terms of allowing a set presumption, clearly, and then the shifting of the burden for ongoing need, if you will, of the recipient spouse to take advantage of it.
Just ask them, so Section 4A speaks to that it's prospective with respect to alimony judgments, and you've given your view as to that. And then, so that's the prospective language, and then there's 4C. Under no circumstances shall Sections 48 to 55 provide a right to seek or receive modification of an existing judgment. Now it's a little different, in which the parties have agreed that their alimony judgment is not modifiable, that's, or have expressed their intention that they survive. So what's the difference there between provisions in a judgment that they aren't modifiable as compared to surviving agreements?
Well, I think the provisions in a judgment that aren't modifiable talk to the issue of property division, basically. Once fixed, that can't be done. But people
That's
have
by
always been
law.
able, I'm sorry.
That's by law, but
Right.
so there are other things that people could agree to?
People could agree to a binding surviving alimony obligation, for example, as we've talked about. They may provide for, we really can't provide for binding provisions for children anymore.
Already says that that's a different thing. A surviving judgment is different from a merged judgment in which they've said, they've expressed their intention as to certain
I think that
parameters
gets the
regarding
contractual rights, because if you have a surviving agreement, in addition to having a judgment, you have a surviving contract that talks to. I see my time is up. It goes so fast. I just would say that I do have other issues raised in my brief,
You could finish
especially
your answer.
addressing the contract.
I'm sorry, you're not cut off just because of the light.
Okay.
You should feel free to just conclude your answer.
There are constitutional issues that are argued in the appellee's brief in this case. I would just point out that those were never directly raised in the lower court. I have addressed some of those issues here in my brief, and the other issues that I haven't covered, I'll rest on my brief. Thank you, Your Honors.
Good morning. May it please the Court. I'm Michael Doherty, and I represent Roberta Rodman. I will argue that the plain language of the Act does not allow its application to post-Act, to pre-Act judgments, that the rules of statutory construction and interpretation do not allow retroactive application here, that the provisions in the Act allowing deviation, the importance in the Act for material change in circumstances, and the unique treatment of long-term marriages all support our position, as does persuasive case law from Tennessee, the Hay versus Hay case I said in my brief, as to this Court's own decisions in Hay versus Clothier.
How do you interpret the phrase "under a subsequent modification" in Section 4A?
4A, Your Honor, clearly relates to 4B. 4A, 4B, 5, and 6 all have to be read together. Rules of statutory interpretation say you must read the entire Act together, giving meaning to all of the words. It is only under a prospective application that meaning is given to the words in 4A and 4B. The or otherwise under this Act in 4A clearly references 4B. 4B tells us that the Act itself is not a material change in circumstances, with the one exception of the durational limits. The reference to material change in circumstances ties into Section 49E of the Act and long-standing Massachusetts law requiring a material change in circumstances for any complaint and modification. We know 4B creates that one and only one exception to that requirement of material change in circumstances. Now we get to 5 and 6. And Your Honors, Justice Corder, you were right. 5 and 6 have to be read together. 5 is clearly derivative of 4B. 4B sets out the exception of durational limits. All 5 does, in clearly referencing 4, is give us a timeline, the phase and schedule of when people can bring complaints for modification for exceeding the durational limits. Similarly, Section 6 is derivative of Section 5 and Section 4. This is clear in at least 3 ways. First, the introductory phrase of Section 6 says, notwithstanding clauses 1 through 4 of Section 5. Clearly, Section 6 is making an exception to Section 5. Next, and to the point Justice Cordy made, it allows someone who's going to retire in 2015 to file a complaint for modification in 2013. How could the legislature allow a complaint for modification based on retirement, if retirement's a triggering act, 2 years before the retirement? That makes no sense. The material change hasn't occurred yet. That'd be a clear violation of Massachusetts law and not make any sense. But when you look at the dates, and when you look at the fact that the date that a person under Section 6 who has both exceeded the durational limits and now has either retired or is going to retire in 2 years may file their complaint for modification, you see it as the exact same date allowed under Clause 1 of Section 5, the earliest possible date someone can file a complaint for modification under the durational limits. Clearly, they're all tied together. It only allows someone who comes into two of the percepted prior ills, retirement age and durational limits, to go to the front of the line and be first in line. That's my interpretation, Your Honor. 4, 5, and 6 have to all be read together to give meaning to the entire Act.
And are you saying that that a person in those circumstances would, the judgment or the modification would occur on retirement, not until then?
No, In those circumstances, when they've exceeded the durational limits, I think they'd have a choice, wherever they fall in the durational limits, and then in the retirement. Your point, Your Honor, is that it'd have to be both, because retirement gets them to the front of the line. So if they were...
Retirement gets them, well, but potential retirement gets them to the front of the line in terms of filing. I'm just asking whether you think, even though the retirement isn't going to happen for 2 years, they would already be entitled to take advantage of the durational limits? Is that what you're saying? In other words, let's say
they'd have to, in order for 6 to apply to someone, they already would have had exceeded durational limits. So the retirement is never the trigger, because Section 6 is derivative of Section 5. You have to be inside, you have to have paid beyond the durational limits in order to have Section 6 apply to you, because Section 6 is derivative of 4B and 5. That is my position, Your Honor. And I think it's the only way to read the statute that gives meaning to all of its terms.
Just let me understand what you're saying. Are you saying that in the case of an anticipated retirement, a person can file an anticipatory modification complaint that could only allow the cessation of alimony upon retirement?
No, Your Honor, that is not what I'm saying. I'm saying that Section 6 is purely derivative of durational limits. Someone has to have been paying beyond the durational limits in order to file a complaint under Section 5 or Section 6.
So if somebody had a 12-year marriage and they were 63 and they were going to turn 65 and reach the Social Security age in 2 years later, but they've already been paying for 13 years or something, or whatever.
Beyond the
enough
durational limits.
Yeah, beyond the durational limits. They could come in and immediately, or whenever the judgment entered, they would be able to stop the alimony.
Not stop the alimony, file a complaint for modification that would give the court a right to deviate. And I want to make sure...
Right, I understand that. But if the court did, it wouldn't, all I'm saying is if the court didn't deviate and did that, the judgment would be effective, wouldn't necessarily wait until the person turned 65.
Correct, Your Honor, because they paid beyond the durational limits. I want to emphasize the importance of deviation. The theme of deviation is a string that runs throughout this entire statute, and it's important because it gives our trial judges the discretion they've always had. Now, I'll say if you look at Section 49F, the beginning, talking about how alimony shall terminate once issued. Once issued is prospective language. It's not. This statute doesn't say all existing alimony judgments. Because as I argue in my brief, I think this court can decide this issue on the plain language of the statute. But beyond that, let's look at how Section 49F1 and F2 would be applied in the competing interpretations of the statute. F1 allows deviation at the time of initial judgment based on the standard of good cause shown. F2, which my brother says gives my client a fair shake, requires for an extension of an existing order a finding of a material change in circumstances. In my interpretation of the act prospectively, that makes perfect sense. Someone after March 1, 2012 had their shot at deviation, entered into a judgment that had a termination date, and if they go before the court again seeking to change an existing judgment that has a termination date, they should have to prove a material change in circumstances to deviate from the existing judgment. That's consistent with our law and the burdens of proof under modification. But now look how it's being applied to my client, or attempting to be applied to my client. She's being told that she has to show a material change in circumstances since the initial judgment in order to deviate. If that is accepted, Your Honors, that would create two unequal classes. It would be unfair, a violation of due process and equal protection, because unlike every recipient after March 2001, my client never gets the chance to just show a deviation based upon a good cause shown. And that's important. Look at Section 53C. That's in there. And other places in the Act, a trial judge is allowed to deviate for good cause. I suggest to you that this application under 49F2 shows the prospective nature of this action, because it would be completely unfair to require my client to show material change in circumstances to retain the benefits of an agreement she already bargained for. I know my time is starting to run short, but I want to make sure I hit some other important points. Well, I don't think that you need to look beyond the words in this language. Justice Duffley, you asked about the statutory history. I think you're referring to Justice Representative Fernandez's comments, and that's attached in the amicus brief from attorneys Novich, McBride. Clearly, he says this act is meant to be prospective.
Could I just ask on a point there? I think it's a amicus brief by Mr. Lee that says that is with respect to an earlier version. He doesn't, and that the later version shows that somehow is indicative of a claim that of all his concerns were no longer, were addressed in the earlier version but disappeared in the later version.
I don't see that at all, Your Honor. I disagree with Mr. Lee's brief. I think that the statute didn't change that much in the versions. The representative language there was talking about it being a prospective language, and the way they emphasized that being a co-chair, I can't imagine it would have disappeared. But more than that, all we need to do is look at the language in the Act itself. And the language really is, when you think about how you're going to apply it, it is fairly clear. And I want to make very clear to my particular case, to my client, who was, after a 39-year marriage, divorced in 2008, 3 years before this action started, at the age of 61, when both parties had to have retirement in their minds, reached an agreement that only allowed for it to terminate on her remarriage or the death of either parties. It would be manifestly unfair to change that. I will rest on my briefs, but I will make the point that because it was a long-term marriage and the importance of long-term marriages, the one exception of duration limits does not apply in this case. The complaint did not allege a material change in circumstances. So not only do I ask the court to find the act as prospective and not applicable to pre-act judgments, I ask you to direct the lower court to dismiss the complaint because it did not allege a material change in circumstances and therefore should be dismissed for failure to state a claim as was alleged in stated in the affirmative defenses. Thank you.
Thank you. We'll take our mid-morning recess at this time.